right. And now what am I doing? How did I get there? Oh,
That was me. Sorry.
oh, you're doing that, Eric. Okay, so
Yeah.
thank you, Eric.
Sure.
Good morning.
Meeting's starting, so let me tell you what I've done. Andy Bartnick is
Marshall.
not gonna be on the-
Marshall,
Good
we can
morning,
hear you.
Marshall.
Marshall.
I muted him. It's okay.
Thank you. He's talking to a friend of his over in Newbury about.
By the way, have you seen
Huh?
that opinion piece that's appearing and has appeared? It's a paper
Yes.
all over the
Yes,
state.
somebody sent it to me. Yeah,
Yeah.
I've been getting a lot of emails. Anyhow,
what?
good morning. This is Senate Judiciary. We are live on YouTube and we are live on the legislative page. This subject is raise the age law that we passed in 2018 and youthful offender laws that were updated in 2018. And Eric Fitzpatrick is going to do a walkthrough on both raise the age and youthful offender statutes. And then we're going to hear from various practitioners who deal with this about possible changes in the upcoming legislative session to both initiatives. And so why don't you take it away, Eric? And Eric is going to go through the statutes, and I would say there's a great deal of confusion amongst even practitioners, but certainly people out in the community, between the two different statuses: one, raise the age, and two, youthful offender. And raise the age, we raise the age of persons who can be dealt with in family court in 2018, and it became effective July 1, 2020, that 18-year-olds would be dealt with in family court. The youthful offender is a different statute and has created some confusion. Eric, please.
Yes, thank you, Senator Sears. And this is Eric Fitzpatrick with the Office of Legislative Counsel, here to talk with the committee for a few minutes this morning about the juvenile proceedings and raise the age statutes, as Senator Sears was just indicating. Before I pull up the screen and look at the statutes, I'll just give a moment or two of background and also point out that the statutes on both of these subjects are quite lengthy. So we're not going to cover everything today. I'm just going to try and hit the high points and give the committee sort of a solid grounding. And I think what appears to be so far the sort of major issues that the committee is discussing as far as considering again this year, in particular, what Senator Sears just mentioned about the two concepts of raise the age and youthful offender, and how they are separate concepts. So there's a connection, there's a relationship between the two, or they are two different things. As you mentioned, Senator Sears, the raise the age, it refers to the policy initiative that the legislature has been moving forward for the last few years, which is essentially raising the age at which a person can be treated as a juvenile in the juvenile system. And up until a couple of years ago, that top age was 17. So that once a person turned 18, they wouldn't be treated in the juvenile system, in the family division going forward. If they committed a criminal offense when they were age 17 or younger, then they would have the option of potentially being treated in the family division. Now, as Senator Sears mentioned, in 2020, that top age was raised from 17 to 18, so that now a person age 18 or younger, could be treated in the family division with respect to juvenile proceedings, and that's scheduled to increase one more time in July 1st of next year, 2022. So at that point, it will be 19 and younger. So again, the upper threshold will be age 20. Anyone younger than that, 19 or younger, could be treated in the juvenile system in the family division of the Superior Court. And that's this raise the age process that this committee in particular and the legislature in general has enacted over the last couple of years. Youthful offender, on the other hand, now if you think sort of big picture about the difference between a juvenile proceeding in the family division and a criminal case in the criminal division, there are significant differences between those two things. And for example, whether the confidentiality of the records in the family division, if it's a juvenile case, if it's the fact that the proceedings are sealed so that they are not public, that you do not have a criminal conviction on your record, so that all the collateral consequences involved with a criminal conviction, whether it be having a criminal record on your, a criminal conviction on your record for the rest of your life, consequences about international travel, possession of firearms, student loans, employment, whatever it may be, all those things attached to a criminal conviction, but not to a juvenile proceeding in the family division. The reason I bring that up is because to understand what a youthful offender proceeding is, you have to understand that, because in some ways a youthful offender proceeding, you can almost look at it as a hybrid between a family division case, a juvenile proceeding, and a criminal case, because what I just mentioned about the different consequences of the two types of proceedings are both involved in a youthful offender proceeding. So if someone is the subject of a youthful offender proceeding, they have juvenile probation, just like any other family division case against a young person. There is juvenile probation. But whereas a family division case, a juvenile case, in the family division, is subject to supervision by DCF, Department of Children for Families. On the other hand, a youthful offender is subject to supervision by both DCF and the Department of Corrections. So there's joint DOC and DCF supervision. Each of those agencies has to designate a case manager, and they decide who's going to be the lead case manager, but they're both involved. And the reason that's important is because you think about the way it could play out. If this youthful offender violates the terms of their juvenile probation, then the court can revoke their youthful offender status and send that case to the criminal division for sentencing. On the other hand, if they comply with their juvenile probation, if they satisfy the terms of what they're supposed to be doing for purposes of juvenile probation, then they can be treated as any other juvenile proceeding in the family division would be treated. So in other words, if they comply, then all their records are expunged. In the criminal division, the records are expunged. The records in the family division are sealed. They're discharged from probation. They don't have a criminal record. They have all the advantages that a juvenile proceeding generally has. So if you think of it, it's almost like an incentive and disincentive situation, right? That person has the incentive of being able, if they comply with their probation, they get all those advantages of not having a criminal record, never having the collateral consequences, et cetera. If they don't, case goes back to criminal division and for sentencing, and they do have those consequences. So that describes a youthful offender proceeding. As you can see, it's different than the raise the age concept, which is just this overall policy initiative of the legislature to raise the age. There's a connection, which I'll mention when we look at the statute, but it's important to understand those two concepts, I think, before we even look at the statute. So that's kind of what I wanted to lay out there for a moment. If there's any questions about that, I can pause here, or I can share my screen and we can look at the language for a moment. Senator Sears, I think you're
Eric,
muted.
yeah, I was. That'll be my epitaph. Muted. Now I'm muted. At what point is it a public process, the youthful offender? At what point does it become a no longer a public process? So in other words, the police, the victim, the press, whoever wants information. At what point does a YO, a 19-year-old, let's say right now, at what point there may be a motion to treat as a youthful offender, but at what point does it become, the information no longer become public? Which
That's
is
a very
really
good
the
question,
subject
sir.
of S 107. And I think before we try to tackle what was 107, we have to make sure we can answer that question.
Right. Yeah, I didn't work on S107, so that's an excellent question, but I don't think I could answer it off the top of my head.
But I think that's what created much of the confusion in the governor's veto message, was he conflated the two separate youthful offender statutes with the raise the age statute, which would be effective for an 18-year-old. But I always believed that everything was public until the court agreed with the motion to transfer to family court under YO.
Right.
So I
will.
think
I will.
we could use clarity on that. Obviously, the Government Operations Committee is a public record. We're working on it, but I think it would be helpful for all of us to have clarity on that. And that came up in a case where I was dealing with not a constituent of mine, but I was referred by a Northeast Kingdom senator to a couple who had been in an accident with a 19-year-old. State police told them that it was a juvenile case and they couldn't talk about it. It really wasn't, because all that had happened was that the defense counsel had made a motion to transfer family court under YO.
Yeah, I would assume at that point it's still in the criminal division.
Yeah, I mean, he was actually incarcerated, so it had to be a public.
Right. Yeah, I would think that's the case, but I will follow up on that for sure.
Yeah, I think we need to make sure we're clear on that. Okay.
Great.
But other than that, you did a great job of outlining the.
Yeah. Oh, good. Thanks. Well, let me share my screen for a second, and let's look a bit at the language as to how these proceedings get started. All right. So this is a document that I prepared that you all have. It's on the website, and it's sort of as a marked up version of the statutes. And what I've done, as you'll be able to see, is I've taken the statutory language. I should ask, sorry, can everybody hear me?
Yes.
Okay, great. And highlighted and bolded, and because the language itself can be a bit thick. So I've, in a couple of different places, you'll see I've added what you see in red italics is not statutory language. That's sort of an attempt to sort of nutshell, a takeaway, I called it, from what the paragraph is that precedes it, so that you'll have this and be able to refer to it. It may be helpful as you're looking at what the actual statutory requirements are, because as you mentioned, Senator Sears, sometimes these things are conflated and it can be a bit difficult to follow. So hopefully that will be helpful. But it's, I think, good to get a big picture sense here of which proceedings do end up in the family division and which are in the criminal division, and why it is that they end up in one place or the other. And generally speaking, that turns on how old the person is and what offense they committed. Those are kind of your two variable factors that will most be involved in where the proceeding ends up. So generally speaking, you can see, and we're in the juvenile proceeding statutes right now, generally speaking, jurisdiction in the family division, I'm at the very top of the page, it's the family division that has exclusive jurisdiction over delinquencies. So that's fine. So how do you get there? How do you get into how does a delinquency get started in the family division? And you see under 5201A 1 and 2, there's two different ways. It can be commenced by, this is delinquency proceedings. How could it get started? Either, number one, the case gets transferred from another court, and that generally means the criminal division. So there's certain circumstances under which a criminal case can be transferred from the criminal division to the family division for a delinquency proceeding. So that's one way. Number two, just a filing of a delinquency petition by the state's attorney. So this SA could file the petition directly in the family division. And there's two, so those are the two ways that the delinquency case could end up being there in the family division. So the question then becomes, all right, well, which cases end up there? And as I mentioned, that depends on how old the person is, what offense it is. And I'm going to just jump right to the takeaway of C here, because this is the big picture of where it is that this case ends up, whether, because there's two options really, right? The criminal division or the family division. What circumstances dictate where the case ends up? Subsection C there, look at the red italics below it. The big picture there is if it's a Big 12 offense against a child age 14 to 21, has to start in the criminal division, unless, and there's one exception, unless the state's attorney files the youthful offender petition in the family division. So that's, if you think about it, then if you've got a big 12 offense against a child of that age, 14 to 21, there's two options. The two options are criminal division, or the SA can file a youthful offender petition in the family division. Those are the two options. So a delinquency proceeding in the family division is not an option. That's not an option for a big 12 offense. It has to be criminal or youthful offender in the family division. So that's the big picture there. And if you look at the language.
And that's age 14 to, but not 22.
Exactly. Yeah.
Eric,
Yes.
if I could just ask, I know this is kind of an ignorant question, but I'd like to hear the answer. What would be the reasons that a state's attorney might file a youthful offender petition in that case?
Well, I think I don't want to speak for any SAs who might be testifying today, and I'm sure they would have a better answer to that question than I would give. But I think it's really to do with the particular facts and circumstances of a given case that they might, and it might help for a moment here. Let's actually, and I had thought about doing this anyway, so thanks for that segue, Senator Brew. We're going to jump ahead for a moment to the youthful offender statute, because as we just mentioned, and as you mentioned, Senator Brew, an option here is for a state's attorney to file a youthful offender petition in the family division. So if that's the case, if that petition gets filed, it's not automatic. I want to stress this, that just because the petition is filed doesn't mean that it automatically becomes a youthful offender case. There's some procedure here that's required and some findings that the court must make. And that, I think, helps answer your question, Senator Brew, because it may turn on whether or not the particular state's attorney feels that it's appropriate given these findings that the court's going to have to make. So here's the youthful offender statutes, a separate chapter of Title 33. And again, it sort of refers back to what we just looked at. A youthful offender proceeding can be started either one of two ways as well. I'm looking at the highlighted language A1 and 2. A1 is what we were just talking about. Can be started by filing of a youthful offender petition by a state's attorney. That's what we just talked about. Remember, it's got to be a big 12 offense, right? Big 12 offense can either start criminal or the state's attorney can start it as a youthful offender petition. Also, you see subdivision 2, another option for how it could get started is that the proceeding could be transferred to the family court from the criminal division. And that's separate from the separate from the state's attorney filing the petition. There's another transfer process that we also want to look at. So let's assume that the state's attorney is thinking about whether or not to file this petition in the family division for youthful offender status, as opposed to going ahead with the criminal proceeding in the criminal division. Again, whether it's a motion, I'm going to pause here for a moment, 5281A. The other way that this youthful offender proceeding could end up in the family division, you can see is subsection A there. A motion can be filed in the criminal division requesting that the defendant under age 22, who over 12 years or older, be treated as a youthful offender. So again, this is a criminal case that's in the criminal division, must be a big 12 offense, but someone could file a motion. And you see the last sentence of subsection A. Motion may be filed by the state's attorney, the defendant, or the court on its own motion. So a case that ordinarily would be in the criminal division because it's a big 12 offense, one of the parties or the court can file a motion to have it treated as youthful offender instead in the family division. So if that's the case, the court family division has to hold a hearing. And they have to hold a hearing on this question of whether or not to treat the case as a youthful offender. There's some other procedural requirements here we can come back to. There has to be a needs assessment by DCF, and there has to be a report by DCF as well as to whether or not youthful offender treatment would be appropriate. All those things come after the petition is filed. But the hearing is what I wanted to mention, because I think this, again, Senator Ruth helps answer your question. The hearing has to be held within 60 days after the petition or the motion. Subsection D there, burden of proof is on the moving party. So remember that it's the state's attorney or the defendant or the court can make the motion. The court does, and the burden of proof is on the youth. But what does the court have to find in this hearing? And Senator Sears, this brings us back to a point that you were stressing at the last hearing as well. At this hearing, the subsection A on the motion for youthful offender status, court first has to consider public safety, has to make a finding about public safety first. And this finding has to be either that public safety will or will not be protected by treating the youth as a youthful offender. If they find that public safety will not be protected, then the motion has to be denied and the case goes to the criminal division. If the court finds that public safety will be protected, then the court can proceed to this next stage and has to make two more findings. But so you see that as an initial matter, court has to make a public safety finding. If it finds that public safety is not going to be protected, motion for youthful offender treatment is denied, case goes back to the criminal division. But if they grant it, they have to move on and make two other findings. And these are findings related to whether or not the youth is amenable to treatment or rehabilitation as a youthful offender, and also a finding about whether or not there are sufficient services available from DCF and DOC to meet the youth's treatment and rehabilitation needs. Remember, as I mentioned at the beginning, youthful offender person is jointly supervised by both DCF and DOC. So again, that's sort of why this finding. So again, court has to deny the motion if you look at B1, if they find the youth is not amenable to treatment or there's insufficient services. But the court grants the motion if they find the youth is amenable and there are sufficient services in DCF and DOC. So,
But I
tracking
want to
back
go
around
back
to
to,
yeah, go ahead. Sorry, Senator Sears.
Eric, can we go back to A, 5284A? That
Yep.
it's so important that we put in public safety. The court has to consider where the public safety will be protected by treating the youth as a youthful offender. And listening to some of the testimony last week, I'm wondering if that really is a practice that the courts are following, or has it just become, whatever. I'm shell shocked at what I heard or what I've been hearing about youthful offender status and how, public safety is at risk, etc. When I look at the way the law was written in 2018, all of these updates in 2018. And I mean, the first thing it says is the court shall first consider where the public safety will be protected by treating the youth as a youthful offender.
Yeah, that's right. It requires this preliminary finding before it goes on to.
So you can't, if the court determines that public safety won't be protected, then you can't even go to the other question. And then you have to make sure the kid's amenable to treatment. You have to make sure that the services are available. Wonder, I guess what I want to ask the practitioners today, is this the case, or have they just sidetracked it and forgotten about these requirements in the practice?
May I also ask a question, Senator Sears?
Yeah.
So when people talk about this, it would be very interesting to hear, I believe, if different states' attorneys approach this differently when they are requesting, if there's any evidence that some counties don't ever ask for youthful offender status and some do, and they do it more successfully. And I don't know what if the court has any guidelines around how they consider whether the public safety would be protected, or if it's just simply up to the judge. And then if they do grant it, they will deny it after the first public safety hearing. Then they will deny it if there are insufficient services. And I would be very curious if the services are available statewide in an equitable manner, so that because there might be some services available in Burlington that simply aren't available in Newport, and so somebody would be not denied there where they might be granted it in Burlington. So I would like when people testify to address those issues also. Thank you.
Thank you. Eric, go ahead.
Yes, thank you. And just to kind of close the loop on Senator Baruth's question, I don't know. Again, I think you want to hear from the practitioners on this, but your question, Senator Baruth, was sort of what factors would go into a decision as to whether to file that petition for youthful offender status in the family division in the first instance. So that's why I thought it'd be helpful to look at these findings that the court has to make, because I would think that some thoughts about whether or not the court would be able to make those findings and whether or not the public safety would be protected, whether they're amenable to treatment, et cetera. I would think that those factors would go into that initial decision.
Right. And thank you, Eric. I appreciate that. I don't want to confuse the issue, but just to tip my hand a little bit, I am thinking ahead to life without parole and the idea that the last time the committee took that up, the Big 12 were, I believe, a carve out from life without parole. And so it struck me that here in the youthful offender aspect, we're saying if you've committed one of the Big 12, there's still a process to determine if you're amenable to treatment, to determine if you're a threat to public safety, et cetera. And then if not, you can get out from the most serious consequences. So just flagging that for the committee as something that I think is humane, and the idea that we will look at each case and determine the threat to public safety, but not deny across the board because it's Big 12.
Okay, thanks. So I'm going to go back for a moment to the juvenile proceeding statute, just to finish up the big picture discussion, just so we know sort of generally which cases end up where. I think that's really the most important pieces I wanted to cover this morning. So we just talked about, remember that the Big 12 offenses, generally speaking, have to start in the criminal division unless the state's attorney files the youthful offender petition in the family division. So that leaves the question, all right, well, what about non-Big 12 offenses? All right, well, that's what you see next in that same section. You'll see if it's a not, and I'm looking at the takeaway language here again as well. You can look at the statutory language also, but just to focus on the picture, if it's a non-Big 12 offense, those start in the family division. That's the general approach. So that's the distinction. Big 12 criminal division, non-Big 12 family division. I think that was the general policy behind raise the age. And not only is it a case of starting in the family division, but it's the raising the age of the non-Big 12 offenses that start in the family division. So as I mentioned, up until I think 2020, that age cutoff was 17 and younger. So 17 and younger cases, non-Big 12 at least, certainly, were generally speaking start in the family division. Starting July 1st of last year, 2020, which is the law that you have in effect now, it's raised 1 year to age 18. So it's age 18 and under, non-Big 12 offenses start in the family division. And you'll see this is interesting, just to point out how this language appears in the green books, in the statutory books. You'll see these are two sections of law. I should say they're the exact same sections of law, but two different versions of the same section, subsection D. And you'll see at the very top line on your screen points out, and this is the way Laxis does this for us when we republish the green books every year, what we work on during the summer and fall. We specifically lay out here that there's a provision that's effective until July 1st, 2022. So that's what's in effect now until July 1st of next year. Then right below it, you see subsection D, effective July 1st, 2022. So in other words, what's below that will be the section that springs into effect, so to speak, on July 1st of next year. And that's because of the raise the age law that the legislature passed. When you passed it with these different effective dates, because you wanted it to be staggered for it to come in gradually over time, rather than all at once. And that's the way it's laid out in the green books to reflect that that act that the legislature passed. So as I mentioned, it's 18 and under right now. And that started last year in 2020. And then on July 1st of next year, you'll see that the age goes up to age 19 and under. Again, and these are non-Big 12 offenses we're talking about. Young people that age and under have to start in the family division. Now, just one last point I want to make, and I think that's probably going to cover the big picture for today, although we can certainly spend as much time on it as you like. As I mentioned, there's a lot here. But just another thing to think about is that we were just talking about where proceedings have to get started. There's still several provisions that allow proceedings to be transferred between the criminal division and the family division. And that makes some sense if you think about it, because, it could be that a case gets started in the criminal division, and after the facts and circumstances are explored or more come to light, it may become clear that in fact the offense is not a Big 12 offense, or it may be that the parties reach some kind of an agreement that it's more appropriate to charge a non-Big 12 offense, and vice versa. So the statutes provide this ability for the criminal division and the family division to transfer the cases between one and the other, to make sure that they're in the right place as far as the requirements that we just described. In other words, that Big 12 offenses are generally supposed to be in the criminal division, non-Big 12 offenses generally supposed to be in the family division. There are some exceptions to that, but that's sort of the general policy, and these statutes in section 5203 permit the courts to make those transfers when it's necessary to comply with those policies.
Eric, can I ask you a question?
Please.
I don't understand here, maybe it just didn't sink in, but if they're required to start in family division, in family court, then why would we have this section in here that says if it starts in criminal court, it can be transferred to family court if it's already required to start in family court? I don't get what this is saying.
Right. I think, and I'll defer to the practitioners on how this might happen more in practice, but what occurred to me on it is that, for example, as an initial matter, it may appear that a case looks like it's going to be a Big 12 case from the facts and circumstances when the case is getting started. So it may start in the criminal division, but then it becomes apparent that either because the facts weren't what they thought, maybe more facts come to light, perhaps even the parties reach an agreement that it shouldn't be a Big 12 offense. It's more appropriately charged as a non-Big 12 offense. Then for all those reasons, they might view it differently after the initial filing, but yet the case is still sitting there in the criminal division. So somehow it has to get back to the family division. So this allows that transfer to happen.
So one of the advantages of family division is that it doesn't taint the youth forever and ever, but if it starts in criminal court, it still is there and there's no resolution. It just gets transferred, and the record is that there was an offense and there was a charge and it was transferred. Why don't we just start everything, even Big 12, in the family division and let them transfer it to criminal when they find it necessary instead of the other way around? Is that a policy decision?
Yes, exactly. Yep.
Okay, thanks.
Sure.
Can I suggest that it was a policy decision, as I recollect, because of what's happened in other states? And there was a fear that if you started all cases in family court, including murders and aggravated sexual assault and heinous crimes, that you would impact that 95% of the cases that do not rise to that level. And at the time we wrote this, I believe that was our concern. So that's why we separated out between the Big 12. We could have also separated out listed crimes, but we chose, the policy choice was listed crimes, but gave the opportunity to have those listed crimes, those Big 12 offenses dealt with in the family court if there were certain situations that
Can I ask you what you meant by it would impact the other 95%?
Yeah, I mean, I think that, No, I think in terms of all of the above resources, yes, but also public perception, public support for the effort,
Oh,
etc., goes away when, kids who have committed heinous crimes are treated in the juvenile court. Look back in history, that's often been a failure of these efforts. So it was a calculated decision, I believe, on the Senate Judiciary's part, committee's part, and then held over through the legislative process and the administration to deal with Big 12 offenses separately.
thanks.
But I also wanted to ask Eric a question about what, and it's not Eric as much as other witnesses to come, as well as the administration that spoke last. I wish we had done this first, actually. But what do they mean by pause? They mean pause raise the age and make it effective July 1, 2023 instead of 2022, which would be a year pause. Are they talking about pausing other things? What exactly is the administration mean by, and that was, I should have asked this last week, but as we come back together later, and future witnesses today, what do they mean by pause? Because I certainly would, I would certainly have, it'd be hard to argue given a pandemic that hit that nobody could have predicted when we made this July 1, 2022. Maybe it needs another year. Maybe it should be July 1, 2023. But I'm not sure what they mean by pause. Okay, Eric, anything else? Or committee, any other questions before we move on to witnesses?
No, I think that's about it. The only last couple of quick points is just that there's other transfer options as well. As you see in subsection B here, this is actually something that predates raise the age. It's been in the law for some time. Criminal division also has the authority to transfer Big 12 offenses to the family division for 14 to 17-year-olds. So in other words, even if a criminal case gets filed in the criminal division for someone aged 14 to 17, there is authority for the criminal division to transfer that to the family division in an appropriate case. And lastly, similarly, that the opposite is also true. If you look here, that the family division also has the authority to transfer non-Big 12 felonies to the criminal division in certain circumstances. So in other words, yes, all non-Big 12 crimes, generally speaking, get filed in the family division, but there is authority for a motion to be made in the family division and for a non-Big 12 felony, not just any case, has to be a felony that's not Big 12, to be transferred to the criminal division. And that requires, I'm just skipping down there just so you can see that there is your Big 12, but also that if that's going to happen, if someone files a motion to transfer a non-Big 12 felony from the family division to the criminal division, that requires a hearing. And that's what I'm looking at right now. There has to be a hearing. Family court has to decide whether, public safety and the interests of the community would not be served better by treating the child under the family division law. So that just, in other words, doesn't happen automatically. It requires the hearing.
Those cases that the administration described then with the teens who were bringing drugs and trafficking guns and other behaviors that were described in our last meeting could actually have been treated in the criminal division.
If they were 14 to 17, yes. I think
Yeah.
if they were, in
Yeah.
other words, if they were this
So
authority
I'm
here.
talking about what was described by, I think the commissioner mentioned the term organized crime, or I can't remember what he referred to, but he was quite emphatic that these were cases that involved felonies, trafficking of guns, drugs, and other behavior. They were, as I remember from testimony from the commissioner of DCF, they were under 18. So that means that even though they were under 18, they could have been, the cases could be transferred to the adult.
I missed that last part, Senator Shears. Sorry, the cases could be
The
what?
cases could be transferred to the adult court, even though they were non-Big 12 felonies.
Yes, that is possible. Yep. It's also possible that, remember we talked about with the youthful offender statute that someone can make a motion for a Big 12 offense, although those were non-Big
Right.
12, you said, right?
That was what I'm only referring to what the Commissioner of Public Safety and I believe DCF and others testified to at the last meeting about certain kids from out of state.
Right.
Yeah.
Yep,
thank
this
you
is,
for-
this is certainly authority for those non-Big 12 felonies to be handled in the criminal division, definitely.
Thank you for bringing that up, Senator Sears, because it caught me by surprise, and I was just stunned to think that there would be no ability to transfer it to criminal court if they really were serious public safety risks and committing very serious crimes. So I didn't understand that at all. So thank you for bringing that up again.
And that's, as I say, there's plenty of more language here to digest. I think now it's probably, I've gone over a little bit. It's probably useful to hold off on this, but we can always come back to it.
I agree, but this has been extremely helpful to me. There's a couple of places I had forgotten.
Great. Go ahead.
And that was one of them. I'd forgotten that we put that into the statute. There may be a reason that the state's attorney can't use it or hasn't been able to use it or something, and we don't know what, looking at I think it was 5284 under the youthful offender, the requirement that you look at public safety. Maybe the courts have, ignored that or gotten around it. We need to hear it. So I am pleased to welcome Bennington County State's Attorney, Erica Mathis. She's right in the courtroom. I can tell there's obviously a fireplace in the courtroom.
Right. Yep. So good morning.
Welcome,
everyone.
Erica.
Hi.
Morning.
First I just want to answer your question, Senator Sears, so the Department of State's Attorneys is not asking to pause the Raise the Age program in statute structure. We're just asking that we improve it. And as you all know, probably more than 10 years ago is when I initially talked to most of you about how I actually believe in the Raise the Age statutes on a number of levels. After practicing in juvenile court for 20 plus years, plus my work in criminal court, I think that there's a lot of good that can be done with the Raise the Age statutes. And I'm not surprised that we're having so many growing pains. And I was a little bit like a deer in headlights last year when it was coming into effect and COVID had hit. And I was pretty panicked about how we were going to deal with those cases when we were all remote and a lot of the services were not operating. So at this point, though, I mean, from my perspective, I would say Raise the Age is not the issue. But I think what Raise the Age did was it highlighted a number of areas of tension between criminal court and juvenile court, the court system, as Senator White mentioned, the services that are available in each county. And this was part of the conversation right from the get-go, that services in each county are not equal. They're really not on many levels. And so the youthful offender and Raise the Age population is no different. So I was listening I logged on early so I could listen to Eric give his kind of, sky view overview of the statutes. And I just had a couple of things that I wanted to throw out there for your consideration. The state's attorneys have developed kind of a restructure of some of the areas that the state's attorneys have had concerns about and that have kind of popped up. And part of the reason they popped up is, as you all know, for the most part, I use youthful offender. I had always used youthful offender a lot. But at the same time that we did Raise the Age, there were some pretty substantial changes made to both the youthful offender process and procedures, but also substantive changes. So when all of this kind of happened at once, it created a few issues for public safety and for the state's attorneys. And so the first one I want to talk about is, and it might be a little bit backwards, but when we're talking about 14 to 17-year-olds can be transferred to criminal court. There are so many issues with that transfer merely because of timing and age. So if I have, for example, and I'll use an example that I had within this last 6 months, which I'm sure DCF and public safety will be well aware of. We had a 17-year-old that was running serious amounts of drugs, cash, guns into Bennington. The two other co-defendants were siblings. They were over 20 years old. They clearly were being charged in criminal court. The 17-year-old, who was actually like only 4 months shy of 18, had no parent. He was on supervision out of another state, another New England state, for a felony assault and through the juvenile program. We had, and he had no parent or no one to take him in. So when we had our hearing in family court 4 months before he turns 18, the court orders DCF custody. There's no way a foster home is going to take someone that has this level of both history and then the current offense. We didn't have anything we could charge in criminal court. It got filed in juvenile. He was taken into custody, and then we had to use up one of our beds at the Sununu Center. We knew he was going to be essentially forced to leave Sununu when he turned 18. DCF was panicked because he was going to turn 18 in DCF custody, and he's at Sununu Center, and they were just going to kick him loose. So we had no ability to have custody once you reach age 18. We didn't have bail. So I filed a motion to transfer to criminal court. Well, you know, Judge Grierson will talk about how backed up the criminal court and the family court are. They both took weeks to get even an initial hearing on that issue. In the meantime, I had the juvenile's attorney indicating that we should just plead him to these charges in juvenile court because through the interstate compact, he's just going to get sent back to Massachusetts. We can close custody, send him back to Massachusetts where he belongs. The issue I had with that is I thought it was rushed. I just didn't think he should just walk in and plead open to a bunch of what would be very serious charges, and even in juvenile court, because it's going to follow him to Massachusetts. So what that created was one example of the 14 to 17-year-olds that, yes, we can charge them in family court. We're required to charge them in family court. We can then make a motion to transfer it to criminal court. Then criminal court gets it. They make a determination about whether, for example, in this case, I ultimately thought a youthful offender would make sense. So that's the second thing I wanted to address that Eric spoke about. We can't direct file youthful offender cases unless they are otherwise able to be charged in criminal court. So you can't charge say an L&L.
Erica, would you repeat that last thing you just said?
You cannot direct file a youthful offender charge or case in family court, like Eric was talking about, unless it's otherwise able to be filed in the criminal court. So that's one of the things that I think is a relatively easy fix. You know, it would give us the ability to streamline and consolidate these hearings so that we have a judge, instead of having a judge here, okay, we have the delinquency case here. Now I have to file a motion to transfer it to criminal court, have that whole hearing. Then I make a motion for youthful offender treatment. So I can then file it, get it transferred back to juvenile court for treatment as a youthful offender. And so I'll give you the worst case example of this. Remember, youthful offender used to be, you would admit to the offense and then we do the treatment part separately. Now, because it's all pre-merits, if I have, say, an 18-year-old charged with masturbating in the classroom, I have to charge that in family court. We're not going to get any kind of treatment, depending on what they're telling us. First of all, we don't have the ability to do psychosexuals on someone who, if they're 18. DCF doesn't have the tools, but they also don't have, there's no statutory requirement. It's not like in a PSI for a sex offense, you are required to engage in a psychosexual, and that becomes part of the recommendations. DCF doesn't have the ability to do that. They don't have anything that's validated for that and for 18-year-olds, and they don't have the statutory authority to require kids to do it. So if I have an 18-year-old that has really significant, if you're engaging in that type of behavior in a very public setting, it's a lewd and lascivious, but it also indicates that you have some significant treatment needs. I have to move to transfer that to criminal court. We have to have a hearing. Then I make a motion to transfer it back to family court as a youthful offender. And we've actually had a situation where I moved to transfer it to criminal. It got transferred to criminal. I filed a motion for youthful offender treatment, and the defense argued it should be a straight transfer back to juvenile court, not a youthful offender. And in the meantime, all these hearings ate up a year, and we're still pre-merits. So by the time we get the merits hearing, even if I prevail on the youthful offender, now we're back in juvenile court. We have to have a merits hearing. We only have jurisdiction to do anything with this kid until he's 19 and a half and he's aged out. So those are like this is kind of like the super minutia that
but
you guys probably like, what the, but.
Well, but yes and no. That's what I'm hoping that actual legislative proposals for change. But I do need to ask a question. I was under the impression from the administration that the Yazzie did not work for sex offenders, and they were going to use the ORAF, the one that the Department of Corrections uses. And I thought that, I remember this coming up when we were doing Raise the Age, and is there some reason that the ORAF isn't being used or doesn't work? Or
I think it could be used. I haven't had a case where it is used because, again, there's no statutory mechanism requiring the juvenile to engage in that. So what we have for typically juvenile sex offenders is the defender general gets their psychosexual or their evaluation separately. If it's, consistent with what the juvenile defender would like to see for this kid, typically they'll share it with, at least in my county, they share it with us. Because we all know the small number of experts that are doing this kind of work. So if I think that makes sense and it's reliable, then I would mirror that. And DCF will do the same thing. But I actually have had DCF say, they can't use the Yazzie. They can't force the juvenile or the 18-year-old to go through an ORS. So, we're really at a loss when it comes to making recommendations about treatment and public safety. Okay,
well, because I could be wrong about what I was assured by the administration back 3 years ago. I don't remember what I had for breakfast yesterday.
Yeah.
But I thought that when that question came up, there was agreement that they would use the ORAF.
Yeah.
So Eric, if you could, next Monday, I believe we have corrections and DCF on youthful offender. If you could ask them that question.
Prior to Monday?
Yeah.
Yeah.
So they're prepared about what it is that needs to change so that they can use the ORAF or any other risk assessment.
So I think the only other example that I just wanted to lay out there. And again, I think I've asked Evan and I've asked Evan, because I'm not super good with a lot of the programming or technology stuff, but I've asked him to, can you put together like a chart? So what does it look like? Where do charges have to start? Where do they go? What are the considerations? It just, when we had the, I believe there was a comment about the, well, if the, if we could just, Big 12 has to start in criminal and non-Big 12 has to start in family division. That's jurisdictional. So there's no wiggle room whatsoever there. I can't file a memo that says, look, here's an 18-year-old that broke his sister's arm. He has it doesn't matter that he has a lengthy history. I can file that as a motion to transfer, but I can't file it as a youthful offender in juvenile court. I can't file it in criminal court. It'll automatically get transferred. The other issue that we run into is when we have 2 or 3 different offenses in one information or petition. We might have an aggravated domestic assault, and then has to stay in the family division. But then we have, maybe an L&L with child that can be filed in criminal division. So now I have hearings and arraignments and paperwork and everything else on two different courtrooms, 2 different tracks, 2 different judges hearing everything. Information sharing in district court or criminal court is brutal because, everything we're relying on is confidential. So when I have my hearing in the criminal court, that's the other kind of big piece of it. How do we file those things? So we've done it a number of ways. We can file it under seal. I've asked the court to close the courtroom just so that we can speak freely about what are the actual issues when we're having this hearing in criminal court. I don't want to have all these conversations on an 18 or 19-year-old in open court about his entire childhood and all of his, psychological evaluations and residential placements. We don't want to do that either. So we just need to do a little bit of tweaking, a little bit of fixing. I don't think, and maybe some of the state's attorneys would kick me for this, but Evan will talk about, he has to deal with them, not me. They, I think that those ages, I don't think we need to change the ages. I think we need to kind of tweak those. I also think I'm going to testify on Monday about specifically the youthful offender stuff. And I think we just need to figure out how to make those flow a little easier so it's not as bulky and messy trying to get between courts. And it takes so much time and it uses so many resources, just this machination between the 2 courts. When we really just want to get help for the kids, get them in the right placement, get them treatment. I think what I had said before, I think I remember saying it to Senator Baruth, maybe more than 10 years ago, which was, 18 is not a magic number where if we have someone I've been dealing with for 15 years that has no supports in the community and no family structure and those don't all of a sudden magically appear when you turn 18. So I think to me, it makes sense that we continue with the Raise the Age project. We just need to work out kind of these problems, these speed bumps, and we didn't, really know until we knew this, right? Until we unrolled it, we weren't going to know what was going to happen. And now we know, and I think we've seen some kind of low points in services and treatment options and all that kind of stuff. But I think those are all surmountable. I think we can do something about them. So.
Thank you very much. Are there questions for Erica? Erica, thanks so much for joining us this morning, and I do appreciate your testimony. And I want to make sure I heard you correctly, and maybe Evan can speak to it, but you said the state's attorneys are not asking to raise the age, but rather seeking improvements.
Yes.
Is that kind of unanimous with the 14 or?
Oh, you always ask me that.
Yeah, I know nothing is ever unanimous with all 14 of them, but is that kind of the general consensus?
Yes. Yep. We talked about this in great detail like a month ago at our in-person state's attorneys meeting.
Wow, you actually have in-person meetings.
Well, I was there by video. A few of us were there by video.
All right. Thanks so much. We'll see you Monday, and if you need to pipe in with Evan, go right ahead.
I'm gonna listen. Yep.
The next witness is Evan Meehan, Deputy Director, Deputy Director, State's Attorneys and Sheriff's Department. I got that right, Evan?
Well, I think my title is Deputy State's Attorney.
Okay.
I think that's what it is. And yeah, thank you for having me today. Again, my name is Evan Meehan. I work in the Executive Director's Office of the Department of State's Attorneys. And I think that I can keep my testimony very brief because Erica flagged a lot of the issues and concerns that the state's attorneys have had. But I'll pick up right where that conversation left off and reiterate that no state's attorney has expressed concerns about the policy of raising the ages themselves. In other words, no one has asked me to advocate for pausing or repealing that policy decision in and of itself. But as Erica mentioned, when the ages were raised and when there were some other substantive and procedural changes made to the youthful offender proceedings, we started to spot some issues, not all of which are new, but maybe were previously underappreciated. And it is those issues that we see some room for improvement. And we think that by making some tweaks, it will really only help support raise the age as a policy. And I think that it can be more successful. The three major issues that I think we would like to see addressed are the lack of a secure placement, which doesn't necessarily have to be a facility secure, it could be staff secure, for all individuals who present a danger to themselves, victims, or the community at large. Hopefully those individuals will be few in number, but we would like to see at least there be placement opportunities in the state of Vermont. The Newbury facility will obviously go a long way to assist in that, but even that facility in Sununu and some of our other locations have limitations on ages and the genders of individuals that they can house. The second area that we would like to see some improvement in is this concept of aging out of family court jurisdiction. I think everyone seems to agree at this point, based on what I can tell, that a rehabilitative focused process for certain aged individuals is appropriate. And so, if that's the concept, it would be unfortunate if certain individuals were deprived of those rehabilitative services just because they managed to reach a certain age before the state could fully investigate, identify a defendant, and then adjudicate their case. And then the third thing that we would like to see addressed, and which I think Erica did a really nice job of explaining, was the procedural ping pong matches that can sometimes happen between the criminal division and the family division. And admittedly, I think that problem has been exacerbated by everyone trying to come out of COVID and re-engage with the court system. And I think Erica also did a great job of explaining that when we try and describe how these problems arise, it quickly feels like we're getting into these minute details of statute that are difficult to follow. And I think that some of that just has to do with the piecemeal fashion in which delinquency and YO, the statutes related to delinquency and YO proceedings have been amended over the years. And I think that if we spent a little time reorganizing and consolidating some of those legal provisions, the law would become a lot more accessible and readable, not just for practitioners, but also for legislators and the individuals who are actually subject to these laws, such as the juveniles and their family members. So those are the areas that we would like to see addressed. We are in the process of putting together sort of an outline for how we think they can be addressed, but we're not quite ready to roll it out to the full committee yet, because we did want to spend some time looking into the issue that Senator Sears identified earlier this morning, which is that public safety standard in 33 VSA 5284, and really trying to understand, is that being applied correctly? Does it have to be clarified or updated in any way? Just so that we get to the place that it seems as though we wanted to get to when Raise the Age was first promulgated in 2018. So those are the things that I was hoping to cover today. I see that Erica is still on the call, and I'm happy to stick around and answer any questions that folks might have. And if I don't have answers today, I will do my very best to track them down and submit them either in writing or at a future hearing.
Yeah, I'm going to start out with a couple of comments and questions. One is, I totally agree that we need to understand how 5284 is being applied in the real world, in terms of the issue of public safety, in terms of the youth being amenable to rehabilitation, in terms of are the services available through DCF in order to do it. And, that I think was written, and how is it being applied? That's, I think, what we need to understand how that can be improved. Second issue is one that I dealt with as director of program for troubled youth for 35 years, is kids age out of jurisdiction. So if somebody's 17 years, 8 months, and you're telling me that I got to take the kid and I got to have changes made in 4 months, it's just impossible. It's not going to happen. So I don't know how to solve that problem since it's been around forever. There were attempts a few years back, I thought, to allow voluntarily to stay in custody. But that's different from actually requiring custody, and I don't know what could be done. The third comment I'll make is I'm not clear in terms of lack of secure placement if we're talking about those under 18 or talking about those over 18. Because my understanding is if you're committed a Big 12 offense, you're dealt with in the criminal division, and you're over 18, you can be housed in a correctional facility. It's when you're under 18 that you have to be separated by sight and sound. And I
Yes.
believe that at one point, the Department of Corrections had 4 beds at Rutland for people aged 16 to 18. And we could ask the Department of Corrections whether or not that's still correct. I'm missing something. But having secure placement, even if it's staff secure, for those 18-year-olds who are being dealt with in the family court, I agree is an extremely important thing. And I think that's one of the, I'm hoping that DCF just got waylaid by COVID and did programs. I would have thought when they were building, the program that Beckett is intended to run, that they would have looked at that age group.
Yeah, and my recollection is fairly similar to yours. And I do think it would be important to hear from both the Department of Corrections and the Department of Children and Families about their inventory of spaces. My recollection from prior conversations, and I hope I'm not misrecollecting the information that I heard, but that the gap seems to be for individuals 18 and over who are eligible to be charged as delinquents. I think we have some capacity for individuals 18 and over who are charged as youthful offenders. But again, I think there are some gender specific limitations on that housing as well. So I'm not entirely, I should have mapped it out before today, but I didn't have time to do so. There are some gaps, but the how big those gaps are is something that maybe DCF and DOC can chime in on. I will say that, many of the state's attorneys recognize this problem while at the same time being very complimentary of some of the folks that we've been working at with DCF, because they have been helpful in working with us and the and some of the sheriffs in finding sort of these temporary places while we can maybe find some place at Sununu or some other location. But there's been a few instances where I think juveniles have had to spend some time in a local PD or some other location for longer than I think folks in general would like. It doesn't happen every day, but it happens occasionally. And, you know, we're hoping that with time, because it will take time, we can build additional resources.
I know there is a place in Bennington where the sheriff is providing 24/7 supervision of a young person who is being held in or being confined in a particular location. I believe that's only one person. I don't know if it's available for two or just one. I know that's in place. I know that there are negotiations going on with another program in Bennington for the 18-year-old. That's more of a supportive placement, helping them get on their feet and get a job, etc. Thanks very much. Eric, could you flag those things too for DCF and DOC as placement options, what they have, what they don't have? And can 18-year-olds who commit a Big 12, I'm sure they're still held in jail, even though there may not be many of them.
Yes, I was jotting those down while Evan was testifying, so I can forward those along to DOC and DCF also.
Okay, great. Are there other questions for either State's Attorney Martich or Deputy State's Attorney Meehan? Thank you to both of you for joining us.
Can I just put
Yeah,
a little
sure.
nut?
Please do.
I,
Yeah.
I just want to put a little thought in everyone's head for maybe Monday. When you were asking and when Evan was talking about aging out, that 18 to 22 population, that's youthful offender would capture a lot of that, because if they get to be almost aging out of juvenile court and they haven't completed programming through their own fault, not if it's through no fault of their own, I wouldn't say that we should extend jurisdiction, but it does give us the option of transferring it back to criminal court for ongoing supervision or programming, you know, and they've already been given a DOC person to work on their case. So it's that transition to me was always very smooth back and forth when it was the way we used to do it. So anyway, I would just put that out there for an option.
Thank you. Any other questions for either, or any comments from either of you? Thanks much. We'll go on now to the defense side of the picture. Matt Valerio and Marshall Paul are with us, and thank you both for hanging out here and listening to the testimony from the state's attorneys. And welcome to Senate Judiciary. Who wants to go first? The boss?
I think I'll go first, if that's okay.
Yep.
Good to see you all again.
Good to see you.
And Matt Valerio, Defender General still. And you know, looking forward to, you know, getting at this issue. I think that probably some of you have seen some comments that I've made in the press regarding the raise the age issue, and that I don't have an issue with a pause in implementation going forward. However, it's probably for different reasons than perhaps the administration has for wanting that same pause. This age group of folks that is contemplated by raise the age, and also falls into youthful offender as well categories, is a group of folks who has been very difficult to categorize and deal with for a really long time. There's been frustration over a long period of time that the youthful offender programs that we had in the past were not being accessed. Vermont, of course, for decades was an outlier in the way that it handled 16 and 17-year-olds who were charged with crimes, where it, until very, very recently, those crimes were, whether they were filed in adult court or juvenile court, was at the sole discretion of the state's attorney. And there was vast majority of them were filed in criminal court, and then there were some outliers who filed them in juvenile court. Of course, this is in the aftermath of the Hamlin and Savage cases back in the early 80s. But Vermont at that time really turned the juvenile court system and the way youthful offenders were treated in Vermont really on its head. And Vermont literally at that time and for many decades became sometimes the outlier of one in how we handled that. In recent years, of course, we've come back to the idea based on some old science and reaffirmation by new science that these are individuals who are not appropriately dealt with in the criminal system. And that so we have these two statuses that are different. And I think one of the things that there was a bit of a we're doing both of these changes with youthful offender and with raising the age simultaneously based upon the same science. And folks who don't work in this area regularly will conflate the two. And they are actually very different in a lot of ways. They have interchanges and they have some interrelationships that Erica Marthage pointed out. And there's some rough spots there. And part of those rough spots are come up when defense lawyers don't make it any easier for state's attorneys to do what they want to do in cases. And I was interested in the description that State's Attorney Marthage talked about with the juvenile case being moved to adult court so it could go back to youthful offender. And then the defense counsel argued that it should be a juvenile case as opposed to a youthful offender case. To me, that is, that's an interesting thing, but that's the outlier. That's not really what we're talking about for the vast majority of these cases. The reason that I am not against a pause, and I think maybe a pause and a review of this at this time might be a good idea, is that we have had cases across the system where youthful clients have, whether they're, and I'm going to talk a little bit about youthful offender, but have checked all the boxes for youthful offender, but the state, DCF, DOC, indicates that it doesn't have the treatment resources available to deal with them. And as a result, youthful offender status was denied by the court, because while they were perfectly amenable to the status, if the state can't provide them what is necessary to address the issues, the court is not ordering it. Now, to me, there has to be something different done with that, so that we don't have people, kids, and youthful individuals, some are over 18, but who appropriately qualify but aren't getting the status because we can't deal with them. Now, I do attribute a fair amount of that to the pandemic. I don't know how much we're coming out of it or stuck right in the middle of it at this point, because I am having extraordinary difficulties hiring people within the public defense system. And hear from Jim Baker that, DOC has problems with it and DCS has problems with it. It's a huge problem all across government to try to maintain and stand up the programs that are necessary to make the system function as a whole. And I just wouldn't want to see, and this is my biggest concern, that the fact that we are trying to stand up this system and expand this system in the course of a pandemic, I wouldn't want to see that and the challenges that we have with that throw the baby out with the bathwater. We should not be in a situation where our inability to currently provide these services to people who are appropriately in youthful offender or would qualify under the raise the age for treatment and resources so that they could hopefully put their life together and put themselves on the right track to doing the right thing. I don't want to see that go away because of our current situation, our global situation that we're dealing with. Marshall is going to talk about some of the details in particular cases and some of the details that might make this work better. But I was heartened to hear that the state's attorneys are not opposing and really don't want to stop the program. I think we all are seeing benefits to youth as a result of it. But by the same token, I don't want to see the program fail because the circumstances are such that we can't deliver what we promised with the statute.
Senator Baruth has a question.
Thanks, Matt. I appreciate that. I'm just wondering if I noticed that each time you addressed the issue, you said you wouldn't stand in the way, or you never said you support a pause. You basically said you wouldn't oppose a pause. And I'm wondering, it sounds when you describe why, like you're saying you support a pause, but you've been kind of careful in not saying that. And I'm wondering, can you just, do you think a pause is appropriate? And if so, what would your suggestion in terms of timing be?
Well, I think that a pause is appropriate in the raising the age situation. I don't think that we should stop trying to do youthful offender where we can do it. And that's where there's sort of, like I said, there's a bit of a conflation of the two programs going on. But if the raise the age adds another layer, adds another group of people, and then we're looking at another raise shortly coming up, I would want to make sure that we have the resources in place before we add more to the system. So to that extent, I support a pause in the raise the age affirmatively.
Okay, and if I could just ask specifically, the administration testified that they would prefer to have heads of agencies and departments determine when to raise the age, as opposed to this committee and other, House and Senate interests putting in a new date. Thoughts on that? Should we? Senator Sears mentioned 2023, I think. Do you think that's appropriate, or do you support what the administration was saying?
I do not. I think that the administration should advise the legislature on what they think is the appropriate thing to do, and that the legislature should make the decision about ultimately what is appropriate from a timeline. I would not, the various departments may have different ideas about it. I'm likely, in my view, DCF would have a different take on it than the Department of Public Safety and the Department of Corrections, and they're all going to have different challenges in standing up the program from a treatment standpoint, from a public safety standpoint. and the like. And, ultimately it's I think the legislature has to say that, we're going to give you, we'll listen to you. We'll give you we'll take into account what you have to say, but we are going to have to create some deadline to make sure that you act, so that something goes in place. So, the details of that, I do think are appropriately discussed within the departments of administration, advising the legislature, and ultimately the legislature has to put a timeline on it.
Thanks, Matt.
Other questions for Matt or comments, Matt?
No, I'm good, and I'm going to turn it over to Marshall to
Okay,
talk about some of the technical details, and I appreciate you giving me the time.
I appreciate that too. And I do have one question. One of the things that got raised by the administration at the last meeting and in the veto message on 107 was the behavior of certain out-of-state youth who were bringing firearms into Vermont, drugs, etc., and that they were affiliated with certain criminal organizations. I'm not going to go as far as to name them, but that was pretty clear about the allegation. Do you agree with State Attorney Mathis that there is that opportunity to use, or Eric actually pointed out the opportunity to go in a transfer? To adult court.
Yes, I think there is. A statute provides for it. As to the specific allegations or information provided by Commissioner Sherling, I have no information about that at all. We tend to deal with a different clientele, I think. And I really don't know about the specifics of that, but I do know that the statute does provide for a transfer to adult court if necessary.
I think Senator White expressed the concern of the committee very well at that meeting when she said that we hate to see 95% of the cases that routinely go through either diversion or are treated as juveniles upset by this small minority of the cases.
And you are dealing with obviously dealing with people as state's attorneys who have different levels of understanding of the statute, and some might not be fully up on what needs to be done. And similarly with the defenders, not all of them have the same knowledge of the complexity of the statutes. We try to train them the right way, but with anything new, this might be an opportunity for education of the state's attorneys and defenders along the way, as well. I mean, anything new has some bumps, and I think that the administration has appropriately pointed out some, and Erica did as well. As long as there's a commitment and understanding that this is the program as a whole is a good thing, then I'm happy with that.
Thank you.
Thank you.
Marshall. Fly away.
So to begin with, Marshall Paul, Deputy Defender General and Chief Juvenile Defender. And I'll start by saying that, we frankly agree with quite a bit of, what Erica had to say in terms of identifying certain areas of both youthful offender and raise the age, and in particular, not so much raise the age, but youthful offender, where we need to make some tweaks that will improve how the process works. I mean, I think, honestly, the one that she identified about cases having to sort of ping pong around so that a case where it might be obvious to everyone in the courtroom that it's best for it to wind up as a youthful offender case, but it has to originate as a juvenile case, and the way that then has to ping pong from the juvenile court to the criminal court back to the juvenile court, I would agree is completely inefficient. And that's an area where we absolutely need to make some tweaks so that we can make that process work smoother, because frankly, one of the problems that I think was sort of a thread throughout Erica's testimony was that these inefficiencies are highlighted or compounded by the slowdowns in the court generally, that, making a transfer from juvenile court to criminal court absolutely is appropriate in certain cases. And in certain courts, it's done quite frequently. But then what I've seen is that in other courts, it's not done frequently. And as, Erica highlighted, there's courts where that process may start, but it may take so long that it's really not an effective process, not because of anything that's written into the juvenile statute, but just because the courts are so backed up. And that really is a problem that affects this entire process. So, I would say that we're certainly, we see some of the same problems that the state's attorneys have seen. We are very much interested in making those changes. I think mostly it's procedural changes that need to be made, not so much substantive changes. I think it's less about changing which kids are in which courts for which offenses, and more about changing how cases flow back and forth between the courts, what the process is for cases to go from one court to the other, things like that. And, I think it'll also provide an opportunity to address some of the concerns that people have had. Senator Sears, you've raised a couple of times today the question about how that public safety determination is being made by judges in youthful offender cases. And it's, we're just getting to the point now where we have enough data to start to look at that. And, frankly, to me, it's quite heartening. It looks like, in most courts, and there's certainly variation county to county, but in most courts, about 50% of youthful offender petitions are granted, and about 50% of them are either denied or withdrawn. And we would hope that over time we see those numbers skew more towards the side of more petitions being granted, because as defense attorneys and prosecutors and judges get more experience with youthful offender, we're going to know better what cases are going to be granted and what aren't. And we're not going to bother filing petitions in cases where there's no chance of getting a youthful offender petition granted. It's just that, as in the first years of youthful offender, everybody's feeling it out, trying to determine sort of, what standards are being applied and what cases are going to go youthful offender and what aren't. But, frankly, the fact that about 50% of cases are either denied or withdrawn is a sign that people are taking those determinations seriously. I mean, I can tell you from personal experience, I can't get into individual cases one at a time, but I can speak about sort of generalities. I've certainly had cases where I've filed a youthful offender petition, went out and gotten an expert to evaluate my case, because it is if the youth files the petition for youthful offender status, it's their burden to prove that they won't be a risk to public safety if they're granted youthful offender status. I've gotten my expert. My expert has come back to me with a report that I could tell was not going to be helpful, and I've simply withdrawn the petition. So I really do think that a lot of those withdrawals and dismissals or denials are reflective of either defense attorneys and defendants or judges doing that public safety analysis and determining, either yes, this is a safe move to put this case into youthful offender status, or it's not. So while I think we're just getting that data, and there's certainly more to look at, I think a preliminary look at that data shows that that's a decision that's being made carefully. I also just want to touch on the issue of the pause and sort of what the reasons for that are. We've seen it firsthand that the providers that DCF relies on are under a lot of strain right now. During the pandemic, they've been figuring out how to handle lockdowns, how to admit clients during the pandemic, how to keep their staff safe, how to manage staffing shortages. There's not been a lot of capacity to see expansion of that system of care during the pandemic, because there's just been so much else to be dealt with. And I would agree with, Evan and Erica, that one of the major concerns is making sure that we have placements available for kids as the expansion of Raise the Age goes forward. And for that reason in particular, we're not opposed to, and in fact, supporting concept, a pause of the further implementation of raise the age. I would say, I do think that should be time limited. That should be dependent on, I think essentially, frankly, some predictions about when we are going to be back to either normal or achieving some new normal, so that we're working with, providers, care and supervision providers who are not, who are addressing, who are looking forward, not just looking at sort of how to get through the next days and how to get through the next issues that they're dealing with, but are really looking sort of more forward looking, and able to really focus on expansion of that system of care to accommodate these kids. So with that, I'm happy to take any questions. Senator Sears.
Other questions? Yeah. Are there any questions for Marshall? I think both you and Matt have certainly explained well the issues. I'm trying to grapple with the issue of that Evan brought up and Erica and Matt. You have somebody who's transitioning. What is the best way to deal with that? Somebody who's 17 years, 4 months back in the day, I would say, no, there's nothing I can do with them in 4 months. So they got to go somewhere. And what do you do with that kid? I think that is there some way that we can extend jurisdiction through a YO, moving somebody who's, say, 19 when they, under the new law, would come under family court, going YO if they're not completed. They're 19 years, 3 months.
I think that there is a way to do that. I don't know that I would agree with sort of the solution that Evan and Erica were hinting at, but I think that I would agree with something that's fairly close to that, which is to find a way to eliminate, if there needs to be a, if the way to look at it is that that's a youth who really belongs in the youthful offender system, to eliminate the ping pong system of going from juvenile to youthful offender and having to go through the criminal court first. I think there's a way we can do that that won't present constitutional issues. And I think that's something that, frankly, myself and Evan and Erica and DCF can work on through the Juvenile Jurisdiction Stakeholders Group, because I agree that's a problem. And I agree that in a lot of cases, youthful offender is the appropriate way for one of those cases to go. And that currently the system of transferring from a juvenile court case to a youthful offender case is so complicated that it may take too long to be effective. And frankly, in my mind, a lot of the problems, a lot of the issues that come up around youthful offender and juvenile jurisdiction have a lot to do with timing. I mean, court timing really matters when you're talking about young people. It matters more so than it does in criminal court by a lot. And frankly, we're dealing with a court system that has a lot of challenges around caseloads and timing, and that affects, transfer decisions. It affects the amount of time that's available for supervision. It affects kids' youthful offender determinations. I've seen kids be, petition for youthful offender status and be denied that status simply because they were told, look, there's not enough time for you to program between now and when you would age out of the system. But if they had that hearing earlier, there would have been enough time. It was just the delay in getting to the point of having that hearing that, cost those valuable months. That can make the difference between whether a kid gets youthful offender or doesn't. And I'm not saying that kids should get youthful offender if there's, not enough time to program them. We don't want a situation where kids are getting youthful offender and are going out unprogrammed because, frankly, that would just be a way to set the youthful offender program up for failure. It's more about making sure that the court system has enough resources and is structured well enough to make these decisions and make them in a timely manner, And if they can't, we have to look at what we can do to make that process more efficient so that those decisions are made in a timely manner and that delays are not hurting kids who are in the youthful offender or juvenile systems, or frankly, putting public safety at risk because, too long is taken to get to a court hearing.
No, I think we've all seen cases over the years where a kid ages out and it's detrimental to everything that was accomplished before they aged out. And kind of that freedom of I can remember when I first went to college, my behavior wasn't exemplary. I would look back on, and part of it is maybe at 18, I wasn't quite ready to be out more or less on my own.
It's, I think that this entire sort of line of discussion really highlights something that Matt said that I think is important, which is training and the extent to which there's still confusion here. I know that there are counties where the felony transfer provision is used regularly, and I know there's counties where it is virtually never used, and people seem to be more or less unaware of it. I was just involved in a situation the other day where I was talking to a prosecutor in a county who was sort of lamenting the fact that they had no way to securely hold a kid who was on youthful offender status and was accused of a violation of probation. And they were just unaware that there's a provision in section 5285 that says that once a youth is on youthful offender probation, on any allegation of a violation, they can be held in an adult facility, in a DOC facility, by either a DOC or DCF probation officer. I do think there is a need for more training, and some of that has been because this was implemented while everybody was dealing with the pandemic. And while there certainly was a bunch of training, we've also seen, both in the public defense and prosecutorial systems, we've seen a lot of staff turnover during this time, and just frankly, a lot of disruption of the normal process. And I think what that very, very possibly has led to is just sort of differences in understanding, or differences in the depth of understanding of these statutes all around the state, both among defense and prosecution, and for that matter, in the judiciary and among DCF workers as well, and DOC.
Other questions for Marshall? Thank you very much, Marshall. Really appreciate the comments and the discussion. So I guess we will, Peggy, we're going to break a little early. And hopefully Senator Benning will be able to join us. He's dealing with a client who's incarcerated, who we're trying to get out. I guess it's important that he be there. And so is there any other things before we break for lunch? Eric, yes,
Yeah,
start with
quick
you
question.
and then Senator White. Yeah.
Oh, sorry, Senator White, but just a technical question, Senator Sears, you're mentioning some info you wanted to get from DOC and DCF before
Yep.
Monday.
Well, no, actually on Monday, if they could be prepared to talk about.
Oh, I see. And so perhaps to Commissioner Brown for DCF, and who's
Commissioner
your,
Baker.
maybe I'll ask Peggy, what were we going to suggest for DOC, Senator Sears?
We have
Commissioner Baker
Commissioner-
or,
Right,
Yep, Commissioner Brown is testifying on Monday.
yeah,
And from DOC, it's Dale Crook and Gary Marvel, because the new commissioner does not start until November 1st.
okay,
Sorry.
great, thank you, Peggy.
I think somebody's warranty is up and they're just telling you that.
Yeah, that was me.
Oh, okay, well, that's good news. You're getting an opportunity to renew your warranty.
Yeah,
Senator White.
So this is just a little comment that I was thinking of when when Erica was talking about this case where this kid was, it took months to get to the court because of the backup. And I know that there's huge backup in the court system. We just got a letter. I did, the whole Windham County delegation just got a letter from a group of landlords down here who have contracts with DOC for transition housing. And they are very upset because probation and parole is violating them on many of them, not all of them, but many of them. They seem to pick certain people, violating them on technical violations of their probation or parole. And the courts are taking time to hear these. These are technical violations, and the courts are scheduling hearings for them, which doesn't make any sense to me at all, because these aren't new crimes. They're not dangerous people. And so while we have a backlog of cases that aren't being heard, that really should be heard, particularly, well, all of the cases shouldn't be on backlog. We're hearing, I believe, cases that aren't necessarily crucial to be heard. So I just needed to make that comment because that's what we're hearing down here. And it may not be true everywhere else, but that's what we're hearing.
I'm sorry, I don't understand the connection with the landlords.
Well, they have contracts with DOC.
Oh, and
to
the
have
DOC
people living
clients
there,
are,
And then,
yeah.
and then if there's a technical violation, the probation and parole is violating them, and the courts are the state's attorney is, they're taking court time to hear these violations of probation or parole when they're not serious new offenses or, but mainly technical. The connection to the landlords was just that's where we've been hearing it from. I've heard it from other people also, but on technical violations of probation or parole. But that letter came from a group of, I think, 10 landlords here.
Anything else? All right, we'll see you at 1.
Senator Sears,
Yes.
that was actually Senator Benning calling me on the phone, and he said that he does not know if he'll be able to make it at all today. He's trying, but he doesn't know. He has no idea if he'll be able to.
Well, it's too bad, but understood.
Should we stay in the meeting and just take our video and